We had an order on Monday about these RFAs. I've mentioned before that we're now post-discovery except for an expert deposition testimony. Blake is doing her most to keep discovery open, but it's got to end at some point, even if she hasn't collected anything to prove her case. Discovery is when you grab anything and everything that might help you put together a case. Pre-trial, which is where we are now, is when you start whittling all of that down to the basics that you intend to fight in trial. We've had motions to dismiss, a motion for summary judgment, and a motion for judgment on the pleadings. These are all aimed to cut back some of the causes of action. RFAs are another form of cutting back, but they help cut back on the need for time spent in court, either disputing facts or, the part we're focused on today, the authenticity of documents. These are done with what's called RFAs. Team Blake is the one who wanted RFAs in the first place, and they missed the deadline. Wayfarer agreed in the hearing before this latest one that they would allow her to file for these even though it was well after the deadline. They probably shouldn't have, and I never understand their kindness. But we could all hear Judge Lyman kind of pushing them to in that hearing, because as the judge who will be presiding over this trial, it's something he wants too. Of course, even in the kindness Wayfarer bestowed, we still have Team Blake biting the hand that gave them this grace. It does not go unnoticed either that when he gives Blake an extension of time that's usually already too much to ask for, he tends to give her weeks more than she even asks. But in this case, he only gives a few days, and she's already immediately hit them with another request for a privilege log yet again while they're trying to do this in these few days. What is an RFA? RFA stands for Request for Admission, and there are two types of these. One is to ask an admission of fact. That saves a lot of time because it clears things up pre-trial so that they don't have to be disputed during trial. Once a fact is admitted, it cannot be argued in trial. It's admitted to be a true fact, and it is no longer up for dispute. Wayfarer refused to allow them to do that, thankfully, or imagine what mess we'd be in now, but they did extend grace to allow them to authenticate documents. Now, the authentication of documents is not an admission that the information in that document is true. Unlike the admission of facts, what's contained in that document is still up for dispute. It only means, for example, this email I submitted is a true copy of an email I received. It doesn't mean that they're admitting that what's in the email is true. Judges like these because the more that can be determined before trial, the less time required during the trial. They won't have to have witnesses testify to the authenticity of these in court. It can save a lot of time. That's a reason judges are often more lenient with extending deadlines, because it's in their interest as well. I do have to say, I read a book a long time ago that assigned colors to people according to their personality or work styles. The two that stood out the most to me were the reds and the blues. I'm a blue all the way. Blues have the ideas, the creativity, and all the good stuff that brings progress to the world. Inventions, ideas, creations. What we lack is schedules and all the boring little details found in paperwork. Reds, however, live to keep order. They don't have much to offer in the way of new, fresh ideas or creativity. Though they're often at odds with each other, they need each other. The most brilliant attorneys are often blues. They come up with the arguments, the trial strategies, they can sense what the other side is doing and sum them up. But if left to their own devices, things won't get filed on time or correctly. Because blues often see reds as annoying little nags with no imagination, and reds often see blues as undisciplined daydreamers who don't take anything seriously, we don't like working together. So if blues are in charge of hiring, they don't like to hire reds. But we need them. We need them to be in charge of our schedules, our finances, and to check our work. And I say this with love, because you know that I love Wayfarer's team of attorneys. But hire some reds. Please. We've had spelling and typing errors. We've had several situations like this that hurt the reputation. I don't like saying this because I'm on their side. And as I said, I am blue to my core. But as a blue, I know we need reds. And it's time to add some so that these little mistakes stop happening. I'm sure you've learned by now that every aspect of a lawsuit is governed by at least one federal rule of civil procedure. In this case, it's Rule 36. But as you can see within the body of 36, we also have Rule 26B, 37A, Rule 29, and Rule 16E. What we're talking about today is Rule A1B, the genuineness of documents. We also see the points that Judge Lyman addressed, and I've highlighted them here, and we'll see how he applies those in a moment. But basically, he mentions each matter must be separately stated, that the matter should be admitted within 30 days, that a shorter or longer time for responding may be stipulated to under Rule 29 or be ordered by the court. If a matter is not admitted, the answer must specifically deny it or state in detail why the answering party cannot truthfully admit or deny it. These decisions are left to the judge. It's not something that's determined by the number of RFAs. We won't really find case law on this stuff, but they're left to the discretion as the guy who understands the facts of the case. Now, let's look at his order. I'm surprised he allowed this extension, to be honest. Not because I think he shouldn't have. I think he should have given them even longer. But because he's not been so kind to Wayfarer and typically only grants Blake extensions of time. But he did. He didn't give them much time, though, and as I said, Blake's team has already demanded a new privilege log and will no doubt add more demands on purpose during the short time Wayfarer has been given to complete this in the little time that they have. He mentions that Blake has moved for an order confirming that her requests are deemed admitted due to the failure to provide timely responses. And he quotes from the rule saying that they're admitted within 30 days, but that parties may agree to a longer or shorter time by stipulation. He notes that she served these RFAs by the court-ordered deadline of October 10th. It's interesting how he doesn't mention that she missed the deadline and was allowed this extra time by Wayfarer. Then he tells us there are 557 documents, which is a lot. He mentions that on October 31st, that she emailed the Wayfarer parties regarding a set of typographical corrections as to 10 of the RFAs, which is a bigger deal than he's making of it. And we'll get to it in a minute. The deadline to respond was November 10th, but on November 7th, that Blake agreed to the extension of the deadline. And he quotes from the emails where they were discussing this. And then he shows what Wayfarer's response was. They said that the request is defective in form. It does not seek an admission by an individual party based on that party's personal knowledge. Instead, it's directed to 8 parties collectively seeking a collective admission without regard to the individual knowledge of a particular party. Accordingly, the request cannot be answered in its current form with a simple admit or deny without explanation. Then Wayfarer went on, by early next week we expect to circulate a list of documents that we will authenticate by stipulation. Given the volume of documents at issue, this has taken some time. So we have a lot of different people involved here. First of all, there's a lot of defendants. There's not just one. In addition, there's a lot of third parties and non-parties who've had to submit discovery. It's a lot. Now, he's alluding to something here by saying they responded with a single identical answer to each of the RFAs. The hard part about these rules is that they don't distinguish what is for admission of fact and what is for authentication. So it's at his discretion for how he wants to apply his rule. I feel like when it specifically is speaking about disputing facts and needing a separate answer for each statement, that makes sense. But when you're talking about authenticating documents, you're not making admissions of fact. You're not making statements. If there's a lump of documents that have been requested to be authenticated and they have the same question about what exactly Blake is asking for and they think that her request is defective, how are they going to write a separate answer for each statement? If each of the requests for authentication have the same issue, what should they do? Start trying to reword the question for each of them separately? I feel like he's being facetious and hard on Wayfarer as usual, especially compared with his treatment of Blake. But my objection continues here. But again, this is all at his discretion. He says the Wayfarer party's responses are deficient and untimely. In the ordinary course, the failure to answer each RFA by that date would be considered an admission. The responses served on November 13th were deficient as they did not satisfy the conditions for that extension, namely, that the Wayfarer parties answer each RFA with specificity. They also did not satisfy Rule 36A4, which separately provides that if the matter is not admitted, the answer must specifically deny it or state in detail why the answering party cannot truthfully admit it or deny it. These are not responses of admissions of fact. These are authentication only. And Wayfarer had a question about the way Team Blake presented their questions. They felt their questions were defective. And it's probably just me not being able to wrap my head around what he means, but I feel like he missed Wayfarer's meaning here. And interesting to note, in his tattletale letter to the judge, Michael Gottlieb makes the statements that we saw Lyman mirror exactly, as usual. This is not the first time, and you've heard me talk about it before. Something gets brought to the court, Wayfarer has a side, Blake's team has a side, and whatever Michael Gottlieb says, that's what the judge repeats word for word in his order. Twice now, Michael Gottlieb has been incorrect. But it's like whatever he says, the judge takes it and runs with it. Even in the case where he went against what he himself had said in a hearing and what he himself had said in an order, he repeated what Michael Gottlieb said and then had to undo it because he just blindly believed Michael Gottlieb over Wayfarer. So he parrots Michael's words and says the Wayfarer defendant served boilerplate objections to Miss Lively's RFAs, apparently as a placeholder exercise. These are Michael Gottlieb's words if you can't tell the difference because they're often very similar. And he says that they made no other specific objections as to Miss Lively's RFAs. That's exactly what we read in Judge Lyman's order. It's like he copied off his paper. Now, I said I would get back to this, too. This is the email that Kristen has to send because Michael sent defective RFAs. He had the Bates numbers wrong, and it went unnoticed and uncorrected for 3 whole weeks. Think about that. Wayfarer had 30 days to respond. Basically 4 weeks. 3 of those 4 weeks, they didn't have the correct numbers. They should have been given 3 extra weeks for the 3 weeks that they had the wrong numbers. But no, and I feel like had this been Wayfarer making this kind of mistake, Team Blake would have thrown a fit and the judge would have given her 2 months to respond. But we can see that in the date. He supplied these on the 10th, and it doesn't get corrected till the 31st. So 21 days or 3 weeks of the 4 weeks they had. It's so hypocritical. First of all, they completely missed the deadline. Flew right past them. Wayfarer says, fine, we'll let you do it. They do it, give them the wrong numbers for 3 weeks, and then now they're here squawking about not getting it back in time. And the judge allowing it. And now he gets back to this point that the Wayfarer's objections are without merit, that they object to the number of the documents, and he cites a case that says that that's not a good enough reason. There are plenty of cases, though, where judges have ruled that a large number in the hundreds or even the thousands is unduly burdensome and have instructed the other side to narrow the scope of their requests. But not this guy. He says the Wayfarer parties also seem to indicate that each of them is required only to answer with the information as to which they have personal knowledge. That misunderstands the purpose of requests for admission and their difference from other discovery tools. An answering party who lacks personal knowledge or information is still required to make a reasonable inquiry as to its truth, and is relieved of the requirement to answer only if the information cannot be readily obtained to enable it to answer. So he's saying what Wayfarer said isn't a good enough reason. As I said, parroting Michael Gottlieb's words. And it's just crazy to me all the time that the judge just gave Blake for multiple things. We have Wayfarer with little time to respond to these sanctions motions, and though the judge was overly obliging to give Blake an outrageous amount of time to respond that she obviously doesn't need since they seem to have all the time in the world to keep bringing this nonsense. I mean, like I said, they just filed asking for yet another privilege log. He never gives Wayfarer the same grace, and it is beyond sickening. He continues that the party on who they are served is obliged to make reasonable efforts to ascertain the accuracy of the proposed admission before responding, even if he lacks personal knowledge of the facts. And this I really don't understand. How are you supposed to admit to a fact that you're not sure of, and as soon as you admit to it, it's no longer up for dispute. It's considered fact to go on with the trial. A party may not refuse to admit or deny a request for admission based upon a lack of personal knowledge if the information relevant to the request is reasonably available to him. And then he says the only reasonable thing here, the court has the power, however, to permit what would otherwise be an untimely answer after the time fixed by the rule has expired. And this is allowed because sometimes things come up, like being given the wrong numbers for 3 weeks, or 75% of the time that you have to answer. When to do so will aid in the presentation of the merits of the action and will not prejudice the party who made the request. So a short extension would aid in the presentation of the merits of the case and would not prejudice Lively. So give them more time. But no, accordingly, by December the 5th, so 4 whole days, the Wayfarer parties shall answer the RFAs, indicating for each Wayfarer party whether the party admits or denies the authenticity of the identified document or lacks sufficient knowledge or information after performing a reasonable inquiry. And you can just imagine, like everything else in this case so far, whatever they end up answering, if Blake doesn't like it, she's going to be running back to the judge, fussing about it yet again. So I doubt this is the last time we're going to hear anything about this. And as I said, they've already begun the nonsense with 6 new filings, all about a motion to compel documents withheld for privilege. They're still fighting this same stuff about privilege because she has no case.